Unyer is like Europe, harmonized but diverse. And at unyer, we are independent law firms. You might think that Europe has a common grounds for severances and costs in case of termination, but this is not exactly the case, and each country has differences with others. So, for example, do you think there is a minimum severance and minimum notice in each country? To answer the first question, Achim, for Germany, will try to summarize that.
Well, thank you very much, Antoine. Well, in Germany, the minimum statutory notice period depends on the length of service the employee has with the firm. So the longer the employee is with the firm, the longer the notice period.
Okay, and is it the same in other countries, for example?
Yes.
For Austria, it's the same.
Yes, it depends on the length of service for the employer. For the employee, it's only 1 month, unless otherwise agreed in the contract. So you can do something in the employment contract, and it's a very important topic you should think about in the contract.
And in France, would it be the same?
It's the same in France. It depends on the length of service with the company.
In Belgium, it's the same. It all depends on the seniority, but what you're going to see is that at the beginning you have a very low notice period, you will have 1 week, and then it's going to increase dramatically to sometimes after a few years going to 3 months, and for someone who is already 18 years, you will have probably up to many months, and sometimes you can go 2 years.
Well, in Italy, it's pretty much the same. It depends on the length of service and seniority. It's not provided by the law itself rather than by national collective agreements, and it may start from at least 15 days for lower levels, up to 12 months for executives.
And do you guys have the concept and know the concept of indemnity in lieu of notice?
Yes, we have that. In general, as a general rule, unless it's termination for just cause, so dismissal for just cause or resignation for just cause, the party who receives the termination should also receive a notice period. But the same party may decide to waive such notice period and receive an indemnity in lieu of notice. So,
Okay.
In France, you have also the concept of notice period, and in that case, usually the employee has to perform his work as usual, but the employer can waive also the notice period, and in that case, the employee receive a compensation equal to the salary he should have received. But if the employee asks to be released from the notice period, then he will not be paid for that time.
Thank you, Caroline. What about Austria?
Very interesting. It's different in Austria, so there is no payment in lieu. During the notice period, the employee works and receives the money. The employee cannot waive this unless the parties reach a mutual agreement, and the employer can also not decide not to pay, but not to pay during the whole notice, but to make a one-time payment. So there is no payment in lieu as you just described in Austria.
So even when there is a litigation with an employee, you cannot release the employee from working in Germany as well.
Well, not unilaterally, that's correct.
Release from work, yes, but pay.
Okay.
But I would agree with Anna. It's the same as it is in Austria and Germany. What you see often is that employees are put on garden leave. So they are released from duty to work and vacation entitlements are set off. So they receive their salary until the termination date and they have no duty to work. But what we don't have is such a system as just Ottavio described in Italy, which we sometimes regret as employers' representatives.
Okay.
And in Belgium, it's also the employer choice. So the employer can decide to have the person performing the notice period, but can decide also to pay instead, and that's what we call indemnity in lieu of notice. He has the choice, but this is tricky. For example, in notice period, if the employee gets on sick leave, for example, it will suspend the notice. So you may keep the employee for a very long time if the sickness is long. So oftentimes you will have to pay the indemnity in lieu of notice.
So I think in the end, it's quite the same. You have an obligation to maintain the employment contract until the end of the notice. You can release an employee from work during the notice, but you still have to pay the employee the same amount of money he would have received if he has continued to work. Would everyone agree on this statement?
That's a good summary.
Correct.
Exactly, and this even applies to bonus payments.
Good, good.
But this doesn't apply to fixed term agreements.
Of course, of course. And what about severance payments?
In France, employee is entitled to severance payments. The amount depends on the wide sector collective bargaining agreement. And in case of misconduct or gross misconduct, the contract is terminated and then the employee is not entitled to severance payments.
So in Belgium, this is where it's a bit different because the notice, the indemnity in lieu of notice is not different from the severance. So there is technically no severance, and that's why maybe you have the notice period that are longer than the indemnity in lieu of notice is more substantial, which makes the fact that we don't have severance payment minus specific cases like collective termination, when you will have some indemnities that will be applying then.
So I think it's the same in Germany, no
It's
minimum.
absolutely similar to the situation in Germany. We don't have any statutory severance payments unless agreed with the Works Council, for example, in social plans, and of course at any time as part of a settlement agreement with the employee.
For Austria.
Last part, yes, in case of settlements, but that's what we call voluntary severance payments. And in Austria we have two different severance schemes. The old severance system, it applies to all employment contracts that started until 1st of January 2003. And for these older employment relationships, the employer is in fact obliged to pay a certain number of monthly salaries at the end of the employment. For the contracts concluded after 2003, it's the severance system lieu, and this means that the employer pays 1.53% of the salary each month to a special fund, and at the end of the employment relationship, the employee goes to the fund and not the employer. But that's a very, very important topic for terminations in Austria. Please be aware of this.
So basically you accrue and you are covered in
Yes.
case you terminate the contract.
Yes.
I think it's different in Italy. isn't it?
Yeah, it's different, but there are some similarities because in Italy we have statutory severance payments. In particular, we have this TFR, which is basically a deferred payment, which is accrued by every employee and roughly amounts to 1 month per year. And so during the year, the employer accrued this payment instead of paying directly to the employee, and usually they put this money in a pension fund. So at the end of the employment relationship, the employee either receives the entire amount, or if the amount is being put in a pension fund, they may ask the pension fund if they have to get it back if they have the.
Thank you. It's very interesting. And is there any specific categories of employees benefiting from certain protection in case of dismissals?
Yes. In Italy, there are some categories that are protected in the sense that unless you dismiss them for a just cause, a redundancy would be considered null and void. And in particular, pregnant women, parents of children up to 1 year old,
1 year.
Women who have been married in the past year. So, yes, that's the reaction. So for these categories, the dismissal will be null and void. And then, of course, we have disabled people that may be dismissed at certain conditions, and of course, every dismissal that turns being, how can I say, discriminatory.
Okay.
Yes.
And for example, do you have, like we have in France, and Caroline will elaborate on that, protection for employees' representatives? Or?
Yes, but not in the case of the dismissal.
Okay.
But other protections, like if you want to move or transfer a union representative or an employee representative, you have to ask first the union representative office to do so.
Yes, indeed. You say, Antoine, in France we have protected employees. For instance, there are elected members of the so-called Social and Economic Committee or trade union representatives, pregnant women. And in that case, if you want to dismiss such people, the employer is obliged to ask an authorization from the labor inspector. And the labor inspector will check the situation and allow or not the dismissal.
What about Belgium, Pierre? Any specific protection?
Very strong protection for people's representative. For example, you want to terminate an employee who is at the work council for gross misconduct, you have to ask the court first. And actually it's a free world, because even if the court said no, you can say yes and I terminate the person, but in that case be aware that you may have to pay, depending on several criteria, up to 8 years of salary. So you can do whatever you want, but it has a price. Sometimes it's lower, it will depend on criteria like seniority or whether or not you're close or far from the next election of the body. Other protection are lower but still effective for women, pregnant women, for maternity leave, any type of protected leave. Then you can terminate someone. You cannot just terminate the person because of the reason, and then you have to prove that it's not linked to that and the burden of proof is on you. Otherwise, it's 6 months indemnity on top of the indemnity in your notice.
Interesting. In Austria, the specially protected groups would be pregnant women, parents on parental leave or parental part-time up until the 4th birthday of the child plus a cooling off period, disabled people if they have a special status of disability, works council members and apprentices. So these are the groups that enjoy special protection, and this means that you have to get a court's or special body's approval before you can terminate or dismiss them. Disabled people you may dismiss even without the court's approval, but for all the other groups you first have to ask the court or a respective official body for their approval, which can take quite a long time. And in Germany?
Thank you, Anna. Well, also this shows that there are many similarities between German and Austrian employment law. The situation is nearly the same in Germany. So with respect to parents on parental leave, pregnant women, disabled persons, it's basically possible to issue terminations by notice, but you need the prior approval by the authority. So without that approval, the termination would be considered null and void.
So thank you everyone for answering our questions. So you know what to do. Don't ask ChatGPT, ask your law firm an answer to your questions.